Welcome to this comprehensive legal analysis on West Virginia's Zipline liability for 2026. Today, we are examining the $2 million aggregate insurance requirement and the ANSI ACCT 03-219 standards that govern Canopy tour operations. This presentation is prepared by Asterisk Law Group as part of our 2026 liability analysis series. Let's begin by understanding why this topic matters. More than 50 zipline operations in West Virginia, a $2 million aggregate coverage baseline, the ANSI ACCT 2019 standard as the governing document, and a rapidly evolving regulatory landscape that demands constant vigilance. Part 1. ACCT Standards Foundation. ACCT International is the ANSI accredited standards developer for the Global Challenge Course, Aerial Adventure Park, Canopy Tour, and Zipline industry. Founded in 1993, ACCT published the first challenge course industry standards in 1994. Today, the ANSI ACCT 03-219 standard is the governing document for zipline and canopy tour operations. It defines every critical aspect: design specifications, installation requirements, inspection protocols, and ongoing operational management. Understanding this standard is not optional. It is the legal baseline against which every operator's conduct will be measured in court. Let's dive deeper into ACCT International and the ANSI ACCT 03-219 standard. ACCT, as stated on its official website at actinfo.org, is an American National Standards Institute accredited standards developer. The current standard, ANSI ACCT 03-2019, covers challenge courses and canopy zipline tours. It supersedes the 2016 edition and reflects the latest industry consensus on safety. The standard addresses structural design loads, cable tension specifications, platform construction requirements, personal protective equipment standards, staff competency assessments, emergency action plan requirements, and daily pre-operational inspection protocols. You can purchase the full standard at the ACCT store. Scan the QR codes on this slide to access ACCT International's website and the standards purchase page. Under the ANSI ACCT 03-299 standard, there are 4 essential compliance areas every zipline operator must address. First, design and installation, structural integrity, cable tension, and anchor system specifications per Section 2 of the standard. Second, inspection requirements, annual professional inspection by a certified ACCT inspector, plus daily pre-operational checks per Section 3. Third, staff certification, qualified course professional certification, and ongoing competency training for all guides and operators. And fourth, risk management, comprehensive emergency action plans, evacuation procedures, and incident reporting protocols. These 4 pillars form the foundation of defensible operations. Failure in any one area can expose the operator to significant liability. Let's trace the evolution of ACCT standards from founding to the present day. In 1993, industry pioneers established the Association for Challenge Course Technology. 1 year later, in 1994, they published the groundbreaking first edition of Challenge Course Industry Standards. A major milestone came in 2006 when ACCT achieved ANSI Accredited Standards Developer status, signifying an open, fair, and consensus-based development process. The 2016 revision significantly expanded coverage of canopy and zipline operations. And today, the current ANSI ACCT 03-2019 standard governs every aspect of zipline operation, from structural engineering to emergency protocols, forming the legal baseline for operator conduct worldwide. Part 2. West Virginia's regulatory framework. West Virginia has emerged as a premier destination for zipline canopy tours in the eastern United States. The state's natural terrain, rugged mountains, deep gorges, and dense forests provides ideal conditions for world-class zipline experiences. But with this rapid growth in adventure tourism comes heightened regulatory attention. The West Virginia legislature and state insurance regulators have established specific requirements for zipline operators. Let's examine what those requirements are and how they interact with ACCT standards. West Virginia regulates aerial adventure courses and ziplines through a combination of state statutes, insurance regulations, and industry standards adoption. According to the ACCT regulation map, available on the official website of ACCT International at actinfo.org, ACCT tracks state-by-state regulation of aerial adventure courses, ziplines, and challenge courses across all 50 states. West Virginia's regulatory approach incorporates the ANSI-ACCT 03-19 standard by reference, meaning compliance with the standard is a condition of lawful operation. Key regulatory bodies include the West Virginia Division of Labor and the state's Insurance Regulatory Authority. To review West Virginia's specific statutes yourself, scan the QR code linking to the West Virginia Legislature website at wvvlegislature.gov. You can also scan the ACCT Regulation Map QR code to compare West Virginia's approach with other states. 4 key entities govern West Virginia's zipline operations. The West Virginia Legislature enacts the statutes governing amusement rides, adventure sports, and liability frameworks. The WV Division of Labor enforces safety regulations, conducts inspections, and ensures operational compliance. The Insurance Commission sets minimum coverage requirements, including the $2 million aggregate and $1 million per occurrence thresholds. And ACCT International provides the ANSI-ACCT 03-219 standard, adopted by reference as the industry standard of care in West Virginia. Now we come to the centerpiece of this analysis, the $2 million aggregate insurance requirement. This represents the minimum total coverage a zipline operator must carry over a policy period, typically 12 months. Think of the aggregate limit as the insurance policy's total capacity. It caps the insurer's payout for all claims combined during the policy term. Within this aggregate, per occurrence limits of $1 million per incident are standard across the industry. Operators must also carry general liability, professional liability for inspectors and designers, and adventure sports-specific endorsements. The ACCT Insurance and Risk Management Committee, you can find its members and resources on actinfo.org, develops industry guidance on appropriate coverage levels, risk transfer mechanisms, and emerging liability trends. Let me emphasize this point. Failure to maintain the required insurance coverage can result in license revocation, personal liability for the business owners, and exclusion from industry accreditation programs. This is not just a recommendation, it's a requirement with serious consequences. Part 3. Liability and Risk Management. Understanding the intersection of tort law principles and industry standards is essential for any zipline operator or their legal counsel. Zipline liability involves multiple overlapping layers. Premises liability for the condition of the property and structures, ordinary and gross negligence for the conduct of guides and management, equipment liability for harnesses, cables, brakes, and platforms, and critically, the enforceability of liability waivers signed by participants. Each of these layers interacts with the ACCT standards in specific ways that can determine the outcome of litigation. Let's break down the liability spectrum into 4 categories. Category 1. Ordinary negligence. This is the failure to exercise reasonable care. For example, a guide forgetting to double-check a harness. Ordinary negligence can be waived, but only if the waiver explicitly mentions negligence by name. Category 2. Gross negligence. This is reckless disregard for safety, such as operating during a thunderstorm with lightning visible. Gross negligence can never be waived as a matter of public policy. Category 3. Strict liability. Some jurisdictions treat zipline operations as ultra-hazardous activities, which can impose strict liability regardless of fault. In Category 4. Premises liability. Operators have a non-delegable duty to maintain safe premises and warn participants of known dangers. Each of these categories demands a distinct approach to risk management and legal defense. Let's address the critical question. Will your liability waiver actually hold up in court? There are 4 legal principles that determine enforceability. First, the express negligence doctrine. The waiver must explicitly mention the word negligence. Generic assumption of risk language is legally insufficient. Courts across the country have consistently rejected waivers that don't specifically release the operator from its own negligence. Second, conspicuous language. The waiver's negligence release must be bold, capitalized, in a separate paragraph, not buried in fine print. Third, minors are unwaivable. Parental waivers for minor children are increasingly being rejected by courts nationwide. You cannot contract away a child's right to sue. And fourth, statutory compliance. Violation of ACCT standards may void any waiver as contrary to public policy. If you're not following the ANSI-ACCT 03-299 standard, your waiver may be worthless. Let's compare enforceable waivers against unenforceable ones, side by side. An enforceable waiver explicitly names ordinary negligence, uses bold capitalized text in a separate paragraph, describes specific zipline risks, requires participant initials on each section, has been reviewed by Adventure Sport Legal Counsel, and is compliant with ACCT standards. In contrast, an unenforceable waiver relies on generic assumption of risk language, buries the release in fine print on the back page, includes only vague references to inherent risks, is signed by a parent for a minor child, has not been updated since before 2019, and fails to reference ACCT standards. The difference is stark, and courts consistently reject waivers that fall into the second category. Let's examine 4 real-world scenarios where liability arises in zipline operations. Scenario 1. Equipment failure. A cable snaps or a harness malfunctions mid-ride. This triggers the strictest inspection duties. The operator must prove through documentation that all equipment was inspected per ACCT standards. Scenario 2. Guide negligence. A guide improperly harnesses a participant or fails to engage the braking system. Under the doctrine of respondeat superior, the employer is liable for employee negligence during the course of employment. Scenario 3. Weather hazards. Operating during lightning, high winds, or icy conditions. This can constitute gross negligence, for which no waiver provides protection. In Scenario 4, installation defects. A tower or anchor system fails because it was not constructed to ACCT specifications. Here, both the installer and the operator may share liability. Part 4. Practical implementation and the 2026 outlook. With increasing regulatory scrutiny, evolving case law, and the insurance market hardening against adventure sport risks, zipline operators must take proactive, documented steps to protect their business, their guests, and their continued insurability. The 2026 landscape rewards operators who treat compliance not as a burden, but as a competitive advantage. Let's look at the specific actions you need to take. Here is the complete insurance architecture every West Virginia zipline operator needs. First, general liability. Coverage for bodily injury claims with a $1 million per occurrence and $2 million aggregate minimum. Second, equipment and property coverage. Protection for cable systems, platforms, harnesses, helmets, and braking systems against damage and failure. Third, professional liability. Errors and omissions coverage for ACCT certified inspectors, course designers, and other professionals whose advice and certifications carry legal weight. And fourth, special risk endorsements. Adventure sports riders that specifically covers zipline operations, weather-related incidents, and participant evacuation costs. A standard commercial general liability policy without these endorsements may leave you dangerously exposed. Part 5. Your 2026 Compliance Roadmap. Proactive operators turn regulatory complexity into competitive advantage. The 2026 season brings both challenges and opportunities. Regulators are scrutinizing adventure sports more closely than ever before. Insurance markets are hardening against high-risk activities. But operators who embrace systematic compliance, documented inspections, certified staff, and legally sound waivers will not only reduce liability exposure, but also differentiate themselves in a competitive market. Here's your action plan for the 2026 season. Here are 5 critical action items for West Virginia zipline operators in 2026. Number 1. Purchase the ANSI ACCT 03-219 standard from actinfo.org. This is your mandatory reference document. Number 2. Schedule an annual professional inspection by a certified ACCT inspector and document everything meticulously. If it's not written down, it didn't happen in the eyes of the law. Number 3. Verify your insurance coverage. Confirm the $2 million aggregate and $1 million per occurrence minimums with adventure sport endorsements are in place. Number 4. Rewrite all liability waivers to explicitly mention ordinary negligence using the express negligence doctrine framework. Have them reviewed by counsel. And number 5. Invest in staff training and certification. Require qualified course professional certification and conduct quarterly emergency drills and document every training session. In conclusion, West Virginia's zipline operators face a complex regulatory and liability environment in 2026. The $2 million aggregate insurance requirement, combined with strict adherence to the ANSI ACCT 03-219 standards, forms the minimum baseline, not the ceiling, for responsible operation. Waivers must satisfy the express negligence doctrine by explicitly naming ordinary negligence. Inspections must be documented. Staff must be certified by the ACCT Qualified Course Professional Program. Insurance must be verified annually with adventure sport endorsements. As stated on the official website of ACCT International at actinfo.org, the regulatory environment is changing rapidly, and operators must stay informed. Scan the QR codes on this slide to access ACCT International, the ANSI ACCT 03-219 standard, and the West Virginia Legislature. Thank you for your attention. This has been a presentation by Asterisk Law Group.